Okay, my name is Bill Norton. I'm here as a part of the Legal History Project for the Nashville Bar Association, sponsored by the Historical Committee. And we have with us today Ray Bucy, bankruptcy lawyer extraordinaire, longtime partner at Gullett, Sanford, Robinson, and Martin. And we're going to be conducting an interview with him to get background on his background and also the practice of law in the bankruptcy area and through his experience. So Ray, thank you for being here.
Thank you for doing this, Bill.
Let's start first of all, I guess, state your full name and your date and place of birth.
Okay. Full name is Glaude. First name is Glaude, like Claude, except with a G. Middle name Rhea, R-H-E-A, Bucy. I was born November 29, 1948 in Paris, Tennessee.
Well, I always knew you as G. Ray Bucy, so I never knew that first name. So now we know. That's great. And where did your family come from? You're always from Paris, or what?
Yes, I think on both sides of my family had been in Henry County for many generations, really going back to when that area first opened up to European settlement in the late around 1820. So my folks on both sides of the family had always been in that area.
Now, what did they do? Were they in the practice of law or just business, or what?
No prior lawyers in my family that I know of. My mother was trained as a nurse, and she spent her working years as a nurse, for the most part, working in the private clinic of some physicians there in Paris. And during my growing up years, my father all those years worked for the Board of Public Utilities of the city of Paris. And so that was, and I had two younger brothers, Ed, who was born in 1950, and Randy, who was born in 1954.
And do they still live there, or what transition regarding your family?
Both of my parents are deceased, and my brother Ed and his family live in Christiansburg, Virginia. They've been up there for 20 plus years. He moved up there in connection with his work. My youngest brother died a number of years ago, so he's no longer living.
And what do you recall in your youth and growing up there?
Well, it was, I would say that Paris was a good place to grow up. It was a nice community. One of the things I remember is that, when the civil rights movement came along and integration came along, it was, the schools were very peacefully integrated without a lot of, fuss and no violence. I think the city had a good leadership always, and a good medical community, and good churches and so forth. I got involved in the scouting movement early on, and stayed with it. Eventually became an Eagle Scout. I went to elementary school at Adkins Porter Elementary, which had been named after two prominent citizens who had given land for the campus. And the school is no longer there. And then after grade 6, I went to junior high school and high school at E.W. Grove High School there in Paris. Graduated in the class of 1966.
All right. And What hobbies, what kind of kept you active? You mentioned scouting, which, is common for the
Yes.
smaller communities and churches and all. I
Yes.
did the same thing myself.
And I was active in the youth group of the church, and then when I got to high school, I got into a little bit of everything. I did virtually everything except team sports. There weren't that many choices in terms of team sports at the time. Football, basketball, maybe the track team, that was it at the time. But I was in the band. I eventually became the president of the student council. I was the editor of the school newspaper, and did a lot of I was on the debate team and in numerous other organizations. So I was had lots of extracurricular things to do, but except for team sports.
Sounds like a leader within the high school that would lead you right into law. So where did you decide to go to college?
I eventually decided to go to college at Vanderbilt. I was really the first person in my family to go to college, and I had a first cousin who was my same age, who at the same time I entered Vanderbilt, she entered a nursing program here in Nashville that was, I think, affiliated with what was then Baptist Hospital. And that led her to a BS degree and an RN certification in nursing. But except for that, I was the first person, we were the first persons in our family to go to college and get a college degree. So I really didn't have that much guidance from my family in terms of where to go to college. I was really influenced by one of my best friends who had already made the decision to go to Vanderbilt. And at the time, I have to say that my horizons were pretty low in terms of what was available out there. I got a real education about that when my own children started going to school, and we visited all of these campuses all over the country. But in 1965 and 66, when I was making this decision, the things that were on my radar screen were it was sort of UT Martin, Murray State, Memphis State. I did think about Baylor University in Texas, Vanderbilt, and Harvard. Those were in my narrow worldview at the time. Those were the choices, and
Right.
So I ended up at Vanderbilt.
When you got to Vanderbilt, what kept you busy?
Well, of course, academics, but I also was involved in student government and kind of student politics. I was, on the debate team. I pledged a fraternity my sophomore year, the Sigma News, and eventually became president of the fraternity my senior year. And at the time, I was sort of interested in electoral politics, and I recall that I think I was a member of the Young Republicans and worked, in some capacity in the 1968 presidential campaign of Richard Nixon. Of course, he later disappointed a lot of us, but in 1968, I spent a good bit of time working on his campaign. And
Well, I probably should state, I don't think I asked you, when did you graduate from high school then, and what years are we talking about at Vanderbilt?
I graduated from high school in 1966 and entered Vanderbilt that fall, and then graduated from undergraduate school with a BA in the spring of 1970. And I was, I joined the Army ROTC when I arrived on campus. This is the fall of 1966. Lyndon Johnson has been president for 2.5 years. There's been a huge buildup of the war effort in Vietnam. And so the one sure way to get deferred until you could complete your undergraduate degree was to go into ROTC,
right,
which I did.
Yeah.
And I completed the program, and when I graduated, got a reserve commission in the Army.
Okay. So you graduated in 70. Then where were you stationed after that?
Well, interestingly, by 1970, Nixon had brought the troop levels in Vietnam way down.
Right.
So there were all these officers coming back from Vietnam, some of whom had gotten a lot of experience and were interested in making a career of the Army. And the service was riffing them out right and left. They had more officers on their hands than they knew what to do with. And so for the first time in anybody's memory, they offered every member of my graduating ROTC class the option to simply go to the officer's basic course in your branch and then take the rest of your active duty commitment in the reserves. Sounded like a good idea to me.
Yeah.
So I had gotten my commission in field artillery, so I went to the artillery school at Fort Sill, Oklahoma, and was there 4 months, and then that was the end of my active duty military career.
And I remember that old red building that was the Army ROTC offices, I think,
Yes.
on Vanderbilt near the law school, as I
Yes,
recall.
that's exactly right. That's exactly right. It's now been incorporated into
Some other business.
the Owen School
Oh, I
of
guess
Business.
it's a part of the business school.
Yeah, they
That's
built
right.
a lot of new construction around it, but they incorporated the old building.
That's exactly right. I remember that. All right. So then, what did progress you after that?
Well, in the fall of 1970, I entered Vanderbilt Law School, and as long as I can remember, I wanted to be a lawyer. Thought I wanted to be a lawyer, even though I had no one in my family had been a lawyer. But there were some folks in my community and who attended my church who were lawyers, and who impressed me growing up as being people of intelligence and who spoke with authority and had influence on various issues, were leaders in the community. So I think that example was something that was attractive to me. And of course, I saw my fair share of lawyer shows on TV. There was one I remember in particular that when I was 12 or 14 years old, aired on Saturday night. It was called The Defenders, and it starred E.G. Marshall, and there was another actor who played his son, and they had a sort of a father-son law firm. And each week was a different case and a different drama, but that, particularly the father-son interaction, I think was attractive to me. So I can't really identify and put my finger on when I thought I wanted to become a lawyer. By the time I hit the Vanderbilt campus in the fall of 1966, I was telling everybody I was going to law school, and that was the direction I was on.
And when you were at Vanderbilt on campus, what's your recollection of Nashville?
Well, when I first arrived in Nashville in the fall of 1966, the Nashville skyline had only one tall building, and that was the LNC Tower.
Right.
when you looked from the Vanderbilt campus downtown, you saw this sort
Yeah.
of level thing of buildings, and then there was the LAC Tower,
Yeah.
and that was it.
Right.
And there were, at the time, of course, there was no liquor by the drink, and there were very few, what you might say, upscale restaurants.
Right.
Just a handful. The entertainment district was what we now see in terms of Lower Broadway wasn't there. I mean, Lower Broadway
Right.
was there, but except for the Saturday night crowd at the Ryman Auditorium, there was nothing going on down there. There was Printer's Alley,
Right.
and a few places like that. I remember the place called the Station Inn where you could go and hear some live music. But so it was pretty. It was quite different from today.
Yeah, it is very different. You're exactly right. And I imagine you probably like me, you didn't really venture out beyond the campus much.
No, I didn't. In the early years, I think Vanderbilt did not permit freshmen to have cars.
That's true. I forgot about that.
So it was a number of years before I got a car.
Right.
So if we wanted to go to a movie in Green Hills, for example, you took a cab or the bus or hitched a ride with an upperclassman who had a car.
Right.
So,
yeah, that made it a little difficult, didn't it?
So yeah, I think I would say that in those early years on the campus, I didn't really learn too much and become too integrated in the life of the city.
Right. So at law school, what interests you?
Well, I was, I guess it was all so new to me. It was all interesting. Some things more than others. I tended to shy away from criminal law. I didn't think I wanted to go there. I thought I wanted a sort of a business commercial law practice. But there were a lot of different things that were of interest to me. I got involved in the Jessup program, which was run by Professor Hal Mayer, and was on the Jessup team my third year, and that's essentially the same as moot court, except that the topic is a topic of international law.
Yeah.
And our team that year was very successful, and we went to the I think made it to the quarterfinal round in the national competition in Washington, D.C. that year. So that was one of my interests. I have to say that midway through my first year, I had a sort of a sinking spell and started thinking, did I really want to be a lawyer after all? I think part of it was maybe a little burnout from the fact that I went pretty much straight through. So that was a part of it. I remember Dean Wade, who taught us torts, said to the class one day something to the effect of, a lot of people kind of get discouraged in their first year and want to quit. And he said, if you're thinking about that, I just encourage you to at least finish the first year and then, evaluate. And so I did. I toughed it out, and then a number of things happened when I came back the fall of 1971 for my second year. Pretty early on, I met the young lady who became my wife, Carol Sanford. Carol had graduated from Baylor University in 1960, 1908, I think, I may have the years wrong there, but she'd come to Nashville to work on a master's degree in history, and we met and started dating. You know, all through college and law school, it was a financial struggle for me because my parents really couldn't afford to send me to Vanderbilt, even though, you know, my first year in undergraduate school, I think the tuition was $1,460, and by the time you got your, you know, your room and board and books and so forth, you could go to Vanderbilt for a year for $3,000 back then. And during my senior year in high school, I'd won a couple of scholarships that added up to about $3,000. Vanderbilt offered me some scholarship money and some National Defense student loan money. And folks who had some knowledge and experience encouraged me to start, and basically said, you know, if you get in there and you do well, you know, Vanderbilt won't let you go. They'll find a way for you to stay.
Yeah.
And those summers of my undergraduate years, I got a job doing construction with a company called Houston Contracting, which put in these big transcontinental natural gas pipelines all over the country, these 30-inch diameter and 36-inch diameter pipeline. And on those, in their work schedule was you worked 12 hours a day, 7 days a week until you got rained out.
Yeah.
But the good news was, you know, you were getting union scale, and you were getting 44 hours of overtime at time and a half every week. So in a summer, after paying my living expenses, I could net about $3,000.
Yeah.
And that would take me a long way through the next year. But by the time I got midway into my second year of law school, I was sort of running out of gas financially. And I went to see Professor Bob Covington. Bob, by the way, was from my hometown of Paris, Tennessee.
Okay.
And I confided into him that I was kind of worried about my finances, and I was also my motivation was at not the right level, and he sort of took it all in, and after about 2 weeks, I got a message from him to call Chancellor Frank Drewota of the Davidson County Chancery Court, who was looking for a law clerk. And so I did and made an appointment to see him. Turned out one of my classmates, Malcolm McCune, was also interested in this and had been invited down. And so we both went and interviewed with Chancellor Drewota, and he was interested in hiring one of us, and so he gave us some briefs from a case that he had under advisement and said, you know, go off and study these and prepare me a research memo telling me how you think the case ought to be decided. So Malcolm and I both did that and submitted our memos, and Chancellor Drewota came back and said, well, he would actually like to hire both of us. So then the question got to be, how could this be done? Because at that time, no trial judges in Tennessee had law clerks. There was no such position. But it turned out that in the Davidson County Chancery Court, there was an unfilled courtroom deputy position. So the clerk and master was brought into the conversation, and it was decided that Malcolm and I would each work 20 hours a week, and we would split the courtroom deputy salary.
Yeah.
And so that's what we did, and that solved a lot of issues for me. Number one, Chancellor DeWoda was a prince of a man,
Right.
and treated us royally. We were being well paid. And most important, I think, is that it really took my motivation from the low level it was way up, because all of a sudden I got to see how these issues and things that we were studying in law school had a practical application.
Right, sure.
And I remember, I'd been studying in civil procedure, the doctrine of res judicata, and Professor Patterson lectured about that, and I was just res judicata was just a total muddle in my mind.
Right.
And the first assignment I got after I actually went to work for Chancellor DeWoda was a motion to dismiss on grounds of res judicata.
Yeah, sure.
So after working on that project, I understood it.
Yeah.
And in the course of that, at the same time, Chancellor Ned Lentz was on the bench in Part 1, and so I got to work with him as well, and just seeing the inner workings of the court, getting to know the personnel, getting to know some of the bar, if only from a distance, seeing them.
Sure.
And prior to that time, I don't think I had ever witnessed an actual trial in any court of anything.
Right.
That was my first experience.
Yeah.
And I stayed on in that role until the fall of 1974, when I went into private practice. And over the course of those couple of years, Chancellor Lentz retired, and Ben Cantrell came on the bench as the chancellor. And so I got to work with Ben, which again was a wonderful experience. Sure. And even kind of on the tail end of things, when Judge DeWoda was elevated to the Court of Appeals, Ed Davies came in and held the position for a while.
Right.
And so I got to work with him. And so that was besides just the academics of law school, that was the transformative experience for me.
Which was a great experience. And so you started that in the middle of your second year?
Yes. And, there was by statute in Tennessee, so much litigation involving statewide issues has to be brought in the Chancery Court of Davidson County. So there were a lot of very high-profile cases. There was the so-called Question 3 that had to do with the legality of one of the amendments to the Tennessee Constitution that had been adopted by a limited constitutional convention that had been called. Mm-hmm. There was a fight between two men named Taylor and Turley over a seat on the Supreme Court. There was the famous afternoon when the District Attorney Shriver brought an action to shut down the movie Deep Throat on the grounds of obscenity.
Wow.
And we all viewed the film in Chancellor DeWoda's court. So there were just a lot of high-profile issues that were really interesting. And so not only did that kind of solve my financial problem, but it really finished out the learning I was getting in law school.
Sure.
And dramatically increased my level of motivation.
So you ended up doing that during the summer of your second and third year too?
Yes. Mhm.
Okay, and then throughout your third year.
Right.
That's great. And then, so I guess, were there any other activities that come to mind during law school? Because that would certainly keep you busy.
Nothing is coming to me at the moment.
Okay. Now you mentioned Carol. When did y'all tie the knot?
We got married in August of 1974. We had probably decided a year earlier than that we would get married. I did not want to get married until I was out of law school and had taken the bar exam.
Okay.
So I graduated from law school in May of '73, studied for the bar that summer, took the bar exam that summer, and was licensed in October of 1973. And by that time, we had decided to marry, and I continued working at the Chancery Court, and then got an offer to join the Martin and Cochran firm. And I joined that firm. My first day on the job was September 1 of 1974. And the previous month, Carol and I got married on August the 10th in Waco, Texas. A very hot August day. And
Is that where she was from, I guess?
well, that was where she was living during her high school years and college. That's where her family was living.
Okay.
She had grown up in northeast Texas, in Fannin County, which is near the Oklahoma border, and was the home county of House Speaker Sam Rayburn. So he was the famous
Sure.
citizen from there. But Carol and I got married August the 10th. We went on our honeymoon, got back to Nashville, moved into an apartment, and I showed up at the law firm on September the 1st.
Wow, not much break in between. That's something. Now, what do you recall regarding like just starting off in a firm? How much were you getting paid during that period of time?
I was my starting salary was $11,000 a year. I had asked for 12, but the man who hired me, Carol Cochran, who was one of the deans of the Nashville bar, I think just couldn't pass up the opportunity to bargain a little bit.
Yeah.
And so I agreed to go to work for $11,000 a year. But I will add quickly that Mr. Cochran was very generous with me in terms of bonuses. And so, he used to say, whenever a big melon comes in, we'll divide it up. And he did. And so, I got before the end of the year, I'd only been on the job 4 months, and I got a nice bonus at the end of the year, and the following year the same happened, and so I was feeling very good about my compensation, and at the time this firm consisted of Carmack Cochran and Joe Martin Sr. They were the named partners, and we had offices in the old Federal Reserve Branch Bank building at 226 3rd Avenue.
Okay.
The firm had the upper floor there. Carmack Cochran's brother, Robert Cochran, was in the firm, and Joe Martin Sr.'s son, Joe Jr., was in the firm, and John Lentz was in the firm.
Okay.
And then I was added.
So about 5 partners or
Yes.
attorneys, and then you were added.
Right. And so that was the firm, and Mr. Cochran was one of the last great generalists. I mean, he would try anything. And he had gotten involved in the railroad liquidation of the Tennessee Central Railway, and had gotten a reputation for being willing to take on an insolvency case. And there in around 1970, this local-based conglomerate called Whale Inc. had gone into reorganization under old chapter Roman numeral 10.
Okay.
And that Quail had attempted to become a kind of conglomerate. That was sort of the rage in those days. And so they had all kinds of subsidiaries. They had a tool and die company and a steel company, and they had a company that was developing Minnie Pearl's fried chicken restaurants in California. And make a long story short, the reorganization failed and went into liquidation. And my first day on the job at Martin and Cochran, Mr. Cochran said, well, we're going to be representing the trustee, the liquidating trustee for Whale Inc., and I think we'll just put you on that and let you help the trustee get that wound up. And so, you know, not knowing anything, I said very cheerily, well, sure, just
Right.
give me the file.
Yeah.
And so he said, like, follow me. And he took me into a room where there were these steel file cabinets lining 3 walls of the room. And he said, these are the files. And he handed me a loose leaf 3-ring binder, and he said, here's the index to the files.
Oh, gosh.
And so I went to work on that. I had taken the bankruptcy course at the law school, which was taught by rookie Tom Sherrard.
Oh, really?
Yes.
Not Hartman?
No. Tom Sherrard taught the bankruptcy course when I took it.
Okay.
And we spent virtually the entire semester on essentially liquidation cases. I think the last day in class, as we were all getting up to go, he did say something about, you know, there's also a Chapter 11 in the code or something as we were heading out the door. But I went to work on this Whale case representing the trustee, and had gotten about 2 months into that. And one day in November of 1974, Mr. Cochran appeared at my door one afternoon and said, do you know anything about Chapter 11? And I told him that I'd heard of it, but that was about it.
Yeah.
And he said...
And this is Roman numeral 11.
Roman numeral
We're still
11.
in that, right?
And he said, well, I'd read up on it a little bit if I were you, because we're getting ready to file one for a company called General Transportation Services, Inc., and its 41 subsidiaries based here in Nashville. GTS was a company that had tried to become vertically integrated in the truck transportation business.
Okay.
So they sold tractors and trailers. They rented them. They had tire companies and parts companies all over the Southeast. Lots of debt. And 1974 was a recession year. And one of the things I learned on that case is that, you know, because of the contraction of business activity, the trucking industry is one of the first ones to feel the effects of the recession. So we got to working on that, and again, you know, we're talking. The governing law at the time was the Bankruptcy Act of 1898, which had been significantly amended in 1938 by the so-called Chandler Act, but hadn't been really amended in 40 years. there had been an effort to make it more usable by adopting some rules. And so the Supreme Court in 1972 had adopted some bankruptcy rules. So, that's one of the first things I started hearing about in that case were the new rules.
Right.
And so got to work on that case, and I spent probably 85% of my time over the next 2 years on that one case.
Wow.
And got acquainted with everybody in the Nashville bar who was had anything to do with bankruptcy, because the bankruptcy bar was so much smaller then than it is now, and virtually anybody who was willing to take on a bankruptcy problem was involved in that case. There were so many.
Who were the major players in that era?
Well, I remember that the major creditors were people like Ford Motor Credit and
Right.
GMAC and so on and so forth. And I remember that Russ Morris and John Bailey from Bassbury and Sims had major roles in that, and Bill Waller Jr. Was involved in the case. Russell Hippie, Bill Lincoln was local counsel for the creditors committee. There was a law firm from Ohio that was the primary counsel, but Bill was their local counsel. But there were lots of other lawyers involved as well. But it was.
And who's the judge or referee at that time?
This was Paul E. Jennings.
Okay.
And Paul was fairly new to the bankruptcy bench. He had not been serving very long. And practice in bankruptcy court then was so much different compared to practice after the Reform Act became effective in 1979.
Right.
For example, the judges were very involved in the administration of the case, and so if one of the debtor companies needed to hire an accountant or open a bank account or do all of these kinds of administrative things, I would prepare a motion and a proposed order, call over to Judge Jennings' office, get an appointment, and I would go over there and sit down in his office, and notice to anybody.
Wow. Yeah.
No notice to anybody. I would just go over there and present them one after the other, explain what it was about. He would sit there and sign the orders, and I would take them out to the clerk, and they would enter them. In those days, when you filed a Chapter 11 petition, you went to the district court clerk's office.
Okay.
You filed them in the district court clerk's office, and then the file kind of came back to the referees. But another thing I remember from that GTS case is that the judges presided at all the first meetings of creditors. And in the GTS case, the first meeting of creditors went on all one day and was continued to another day.
Oh, really?
And Judge Jennings sat up there the whole time, and there was, because the judge was in the courtroom, there was a lot of gamesmanship that went on.
Right.
Because the chief executive of the company was on the stand, and because there were so many creditor interests, they had set this meeting for one of the district courtrooms, because the bankruptcy courtrooms were very small. So one lawyer after another would get up and ask his questions of the CEO, and the whole object was to so embarrass the CEO and make him to look incompetent or evasive or whatever, and to get the judge so riled up right then and there that he would sua sponte convert the case to liquidation. I mean, that's what it was. That's what they were trying to do.
Yeah.
A lot of them were, at least. And that was...
Now, this was all in the district court courtroom, or was this in the Customs House where they're currently located?
This was in the Estes Kefauver building.
Okay,
In one of the district courtrooms.
I see.
Now, and
Is that where the bankruptcy judges were too?
they were on the 7th floor.
Okay,
The entire bankruptcy apparatus, judges, clerks, copy machines, everything was on about 1/2 of the 7th floor of the Estes Kefauver building at that time.
and was he the only judge?
No, we had a second judge, and that was Ruth Kennard at the
Okay.
time. And both were already on the bench by the time I started practicing. Prior to them, Nashville had had one referee, Judge Bates. I guess somewhere along the line, authorization for a second referee was obtained. And back in those days, the bankruptcy judges, referees, were appointed by the district judge, and Judge Gray had appointed Judge Kennard. And I had cases in front of her as well. So it was a very different.
And then when you were dealing with that in this early stage of your career, were you mostly just working on your own, going to court, or was there another lawyer with you?
It was pretty much myself. A couple of years in after I arrived, we hired an associate, Sterling Minor, who was from the Nashville area but had gone to SMU Law School. So he joined the firm, and so of course he worked in the same area that I was, and sometimes Mr. Cochran would be involved in a particular hearing, but a lot of it I did.
Yeah.
And so after about 2 years of that, I sort of had gotten branded, as they say nowadays. We didn't use that term back then, but so after that point, I just started getting a steady stream of referrals in the bankruptcy area, and that's kind of been the course of my career. It's the work I've always found very agreeable. And if you had asked me in law school to describe what I would like to be doing, I would have described something very similar to what my practice has been, although I had no earthly idea how to get there.
Right.
Sort of fell into it backwards.
Yeah.
And fortunately, it agreed with me, and so.
Yeah, I imagine that's how a lot of us end up in that area. So what do you recall, obviously in '78, there was new law. What kind of transitions occurred with that new development?
Well, the act was passed in 1978, and it was going to have an effective date of October 1 of 1979. And so we all started going. A lot of special seminars were being held around the country. I recall going to one in Dallas, which had on the panel a lot of the folks who had been involved in drafting the new act, and it was in that connection that the Mid-South Commercial Law Institute got founded.
Okay.
And with a goal of producing a seminar to help the local bar get ready for the effective date of the new act in October of 1979, and the first seminar of the Mid-South was in that
1979. Okay.
Fall of 1979. So there was a lot of that. It's by then, I guess after probably in 1976, I was doing so much of bankruptcy and was still involved in the GTS case. The firm suggested that I go to the annual bankruptcy seminar at NYU, which was, at that time, Lawrence King kind of headed the bankruptcy department there, and he was the editor of Collier on Bankruptcy. And the NYU Law School had a seminar every August, and they would bring in all of these practitioners and law professors and so forth. And so I went in August of 1976, and so you get to meet and talk to and hear people like Larry King and Harvey Miller,
Sure.
Vern Countryman, who was a professor at Harvard, Frank Kennedy from the University of Michigan Law School, who Kennedy had been very involved in the drafting of the new Reform Act and also those 1972 rules I mentioned, and was a wonderful educator and was helpful to me in a couple of cases in my career during that time frame. So we were all just trying to kind of get up to speed on all of the changes that were going to be brought about by the new act. And
what kind of cases progressed after that for you?
Well, I remember this case actually happened before was governed by the old act, but we got involved in the liquidation of the Frostyborn Meats case. It's a meat packing outfit that had several locations around the country, but they operated a meat packing plant in Clarksville. And really interesting issue came up there because not too long before this, Congress had passed an amendment to the Packers and Stockyards Act, which created a sort of a statutory trust, they called it, on all of the meat packers' products, accounts receivable, and everything, to assure that any unpaid farmers who had sold livestock and hadn't gotten paid, that they would get paid. And as we investigated this, we concluded that this was under the Bankruptcy Act an invalid statutory lien. It was a kind of a secret lien that did not appear of record anywhere, required nothing, nobody had any notice of it, other creditors, particularly secured creditors. So we brought an action on behalf of the trustee to avoid those arrangements, and Judge Jennings recused himself from that decision, I think on the grounds that he owns some cows. And so the case was given to Judge Clive Bear from Knoxville.
Okay.
And Judge Bear took the case, and let's just say he made pretty short work of our argument.
Oh, really?
We appealed it and went to Judge Morton, and we didn't get much. Didn't get any relief there.
Right.
I still think we had a very good case, and it probably was an invalid statutory lien, but the politics of having 150 farmers out there who've delivered cattle and hogs to the packing plant in Clarksville, Tennessee, and who haven't gotten paid. I think, they say sometimes hard cases make bad law.
Well, that's true.
So, but I'm trying to remember what some of the earliest cases under the new act were.
Well, I guess to begin with, in the new act, you didn't have the judge attending the meeting of creditors, so there had to be a difference in how court was being held after that.
Right.
Under the, well, I say new act, under the bankruptcy
Right.
code.
And this was before the creation of the U.S. trustee system, so you didn't have the U.S. trustee conducting those meetings. Generally, the trustee who was appointed in the case would handle them. One of the huge differences between old Chapter 11, Roman numeral 11, and new Chapter 11 was that in the prior act, you could not modify anything about a secured creditor's position. There was nothing you could do absent the secured creditor's consent.
Mm-hmm.
Didn't matter, if they were unperfected, you could avoid their lien,
Right.
but, you couldn't extend the term of the loan or change the interest rate or write down the debt based on the value of the collateral.
Okay.
And so you were entirely dependent on getting the consent of the secured creditors. And if you couldn't do that, usually the result was liquidation. Now, under the old act, you could go into Chapter 10 and modify a secured creditor's claim, but that was not very much used except in the biggest kind of publicly held companies because it involved the automatic involvement of the SEC, automatic appointment of a trustee, so it was not very attractive. So with new Chapter 11, you got the ability to modify the secured creditor's claim in a lot of different ways,
Right.
and that made Chapter 11 a very useful tool that it had not been before. It changed the role of the secured creditors lawyers because the secured creditors lawyers under the old act were had gotten they expected to be deferred to and to be deferred to by the judge when they came into court because of the power they had. That changed when the new law came in, and I think it was a painful adjustment for some who had.
Well, in that day and age, speak a little bit how the firms kind of represented the various financial institutions. You kind of had one group representing one creditor.
Yes, and in Nashville in those days, typically, the banks, which at the time were virtually all locally owned, sort of did all of their business with one law firm.
Right.
So First American had Bass, Berry and Sims, and Third National had Ferris, Warfield,
Yep.
Canada, and so on and so forth.
Right.
Nashville City Bank had Bolt Cummings, and
Yeah.
on down the line. And so when a bankruptcy case would come up, that involved, say, First American, you'd go looking for somebody at Bass Berry to represent the bank. So that was in big strokes the sort of the pattern at the time.
And your firm had was growing during that period.
Yes.
As I recall, you were representing some savings and loans and other things, right?
Right. Now, one thing that I guess I can mention here, and this happened right as the Reform Act was getting passed and becoming law. In July of 1978, Carol Cochran suddenly dropped dead one morning.
Mm-hmm.
He had been my mentor, and he had hired me, and I worked very closely with him. And he had been very active until the day he died. I mean, he really did the work of 3 lawyers. And so making the transition from his passing was going to be a challenge. And then on the Saturday after we buried Carmack on Thursday, my first child was born.
Okay.
My son, John.
And this is what year we're talking?
This is July 1978.
Okay.
John was born July 30th of 1978. And needless to say, the next few months for me were
Wow.
a juggling act. That fall, Tad Harris came over and joined the firm. He had been, since he got out of law school, with Bolt Cummings, and he joined us and provided a lot of help. And just to kind of fast forward a little bit, around 1981, Bob Pope joined the firm, and about the same time, Linda Knight joined the firm after finishing up a clerkship with the Tennessee Supreme Court. She had been in practice in Birmingham before she and her husband relocated to Nashville. So the firm was growing, and just again to fast forward one more step, in 1985, Tom Forrester joined the firm right out of UT Law School, and it was not long after that, effective May 1, 1986, Martin and Cochran merged with the Gullett, Sanford, Robinson firm and formed Gullett, Sanford, Robinson, and Martin. That was May 1, 1986. And the following year, as the old Hooker Keeble Dodson firm was breaking up, Gareth Aden and Scott Derrick joined the firm May 1 of 1987. So by then you had sort of the base of the new firm. Now obviously it's since then some people have left and some have come, but what I'll call the modern Gullett, Sanford, Robinson, and Martin was kind of in place by May 1 of 1987. But to back up, there were a number of cases going on back there in that the period after the new act became effective. But one of the major developments was the passage of the Tax Act of 1987, which essentially did away with all of the tax-driven syndications of real estate and other things. For the next 5 years, we took through Chapter 11 one apartment complex or office building after another. I guess one of the first big cases in Nashville after the Reform Act became effective was the H&S Transportation case that Jim Kelly filed here in 1981. We all joke that Jim should get the award for Lawyer of the Year for filing that case in Nashville. But, this was, we were in the aftermath of Jimmy Carter's embargo of grain sales to the Soviet Union, and this had created a collapse of the grain and barge business all over the inland waterway system in the United States. So in that case, I got hired by a St. Louis firm that had a big position in that case. They were primarily a barge company, and what I learned is that, they sell, barge companies in those days at least, I don't know about today, but they sold futures in barge.
Okay.
So you would sell, you're buying space in X many covered hopper barges departing from the Illinois River on a certain date, and then these contracts would be traded.
Mm-hmm.
And one of the big features of that H&S case were all of these contracts that were out there that involved millions of dollars. As a result of, I guess, making a good impression on the client in that case, they hired me in case after case after case over the next several years that were, grain elevators on the Ohio River in Kentucky and Pittsburgh and Baton Rouge and the whole inland waterway system where you have barge operations and grain elevators were, lots of those operators were going into Chapter 11 in those years. So I spent a lot of time in the early 80s on those cases, and then
that would be, you would be dealing in other jurisdictions then as well,
yes,
right?
yes. So I remember, going to bankruptcy court in Kentucky and Houston and
Right.
New Orleans and
Yeah.
so on and so forth. So that was interesting, and I really liked the client that I was working for then, and they had a couple of in-house lawyers that I really liked working with, and so that was good, and then in 1986 we put the Vanderbilt Plaza Hotel into Chapter 11.
You're right.
And that was really, I guess, in some ways, one of the first cases under the new act that really got us into some of these cutting-edge issues, because the first mortgage was clearly way, way underwater.
Yeah.
So you had the ability to bifurcate the secured creditor's claim.
Right.
Then the question got to be, the secured creditor's unsecured claim was so big
Right.
that it could outvote all the unsecured creditors. So the question that got to be, can you separately classify the unsecured
Still
claim?
needed that accepting class. Didn't
Yes, still needed an accepting class. And so Brad McLean represented the insurance company that held the first mortgage in that case, and we went round and round on that issue in front of Judge London, and it was just very interesting and set some precedents.
Right. Yeah, I mean, of course, you ended up with a whole market after that point of a lot of single asset real estate cases.
Yes, and one of the big issues there, and I know you know something about this, but there was an opinion from Circuit Judge Kurtz that had been done some years earlier, in which he held that a creditor with an unsatisfied judgment could not attach future rents coming off of an office building or apartment complex or whatnot, because the rent did not become a chosen action until the due date of the rent. So this suggested that these assignments of rent, which were conventionally done in these cases, were not perfected as to future rents, and that was the holding in a lot of cases. Now, eventually, I think you know something about the fact that Tennessee law got changed in that regard after some of those decisions. But litigating those cases, I mean, we handled a lot of those cases in the aftermath of the 1987 Tax Act. That kept us busy for 5 or 6 years,
Right.
working through all of that.
And we were having an impact, as I recalled, of the RTC and taking over various financial institutions.
Yes, yes, and my firm, Gullett Sanford, our largest client in terms of revenue at the time was Metropolitan Federal. And the law had changed to permit traditional savings and loans to sell stock and become publicly owned and raise a lot of new capital. And Metropolitan and just about every other savings and loan all over the country had taken advantage of this, raised lots of new capital, and then got involved in making development loans on projects like, the development at Cool Springs and so forth. So when this tax law changed and the regulators of the savings and loans, said, well, you have to mark the value of your collateral down to market.
Right.
And when they did that, even though Metropolitan Federal was well managed and not illiquid,
Right.
when you perform that operation, the result of it was that in 1991, the RTC came in and closed Metropolitan Federal, and scores of savings and loans all over the country, and commenced dumping all of their collateral onto the market.
Right.
And the effect of that on the values is predictable. So that operation cost the government vast amounts of money, far more than they were losing from the syndicators taking losses on depreciating these properties.
Right.
I mean, it was a traditional case of burning down the barn to get rid of the rats.
Yes.
So the rest is history, which illustrates a point I guess I would like to make in my observations over the years is that people tend to think when a company goes into bankruptcy, it always must be some sort of mismanagement or fraud or something. And, there are cases where mismanagement is a factor and cases where fraud is a factor. But one of the biggest factors, decade in and decade out, is the change in government policy. The government sets a policy at one level, and after so many years, another administration comes in, another Congress comes in, and they think that things are not going the way they should, and they abruptly change it. And suddenly all these businessmen who've trimmed their sails in one direction are left flapping in the breeze. And the first time I ever saw it was the aftermath of the Carter administration. In the Carter administration, they were encouraging particularly dairy farmers to put more land under cultivation and build up their dairy herds and produce more milk. And as an incentive, the government was offering to buy the surplus milk and cheese and store it for future purposes. And they offered the farmers all of these government loans at low interest rates.
Right.
And I can remember them calling up the head of the bureau that was supposed to be making the loans, and congressmen really raking them over the coals because they hadn't gotten all this money loaned out. Well, eventually they got it loaned out. The farmers took the loans, built up the dairy herds, And then one day somebody in the government said, we got all this dried milk and cheese. We've got warehouses full of it. We got it coming out of our ears. We got to stop this.
Right.
So immediately they put a surcharge on every 100 pounds of milk that a dairy farmer sells, and start encouraging them to take their dairy cows to the slaughterhouse. And in very short order, virtually every dairy farmer in Middle Tennessee who had any debt went into bankruptcy.
Yeah.
I guess there were some who had inherited their land and had managed to avoid incurring debt, but it decimated the family dairy farmers in Middle Tennessee. And you can see this kind of pattern repeated decade in, decade out. The Tax Act of 1987 and all that followed from that is
Right.
another example.
And the classic example of that, I agree with you 100%, it was in the mortgage industry in the 2000s.
Yes.
2005, 2008, and all of that.
Right, right.
All based on government policy of trying to build more homes and low mortgages, that kind of thing.
Yes.
Yeah. Well, one thing I want to drop back to, you mentioned about the Mid-South. Who was it? You said that it was formed to kind of educate people. I think in Atlanta there was a Southeastern that
Right.
had been going on.
Right.
So who were the prime movers of trying to get that going when that was formed?
Here in Nashville, they were primarily secured creditor lawyers. And I won't remember all of the names, but John Bailey, probably Russell Hippie, Dick Dance, Bill Lincoln, Jim Roberts, who was the in-house counsel at the old Third National Bank, Tom Kennedy.
And I think the focus was more on commercial law as well as some bankruptcy. It's
Right.
maybe evolved more toward bankruptcy in recent years. But
Yes. Well, at that very first seminar, I mean, the focus was getting everybody sort of up to speed on the new act
Right.
that was going to become effective in October of '79. But after that, it did broaden out, and for a number of years, there was a lot of focus on the UCC. White and Summers were frequent panelists on the annual seminar and so forth.
what other activities did you get involved in beyond just the bankruptcy practice?
Well, I've done various things in the Nashville Bar over the years. I've served on various committees, did a term on the board, and so on and so forth. Did some pro bono work. I have been very active in my church over the years. Have served 2 terms on the session out there, one as clerk of the session, and
What church was that?
this is Westminster Presbyterian,
Mm-hmm.
and been on various committees, served on various committees of the church, and my wife also was ordained an elder in that church and has been very active in it over the years. So that was a big activity. And kind of related to that, I've served on some boards of local not-for-profits. There was one called the West Nashville Covenant Ministries, which ultimately merged with several other organizations to form what is now the Campus for Human Development, which operates the Room in the Inn and certain other programs in Nashville now. I was active in as a leader in the Boy Scouts for a number of years,
Okay.
primarily when my son was of a scouting age and he was interested in it. So I became an assistant scoutmaster of his troop and led a group of them one summer on the trek to Philmont.
Belmont, sure.
which I had been fortunate enough to be able to attend as a scout myself when I
Right.
was 15 or 16 years old, and it was a memorable,
Sure.
life-changing experience, and I kind of wanted my son to have that.
Right. And you said your son was born in 78. What other family?
78.
Yeah.
My daughter, Ellen, was born in 1981.
Okay.
And Ellen graduated from Indiana University, got a master's in English from Columbia, eventually married a young man from Sweden, Bjorn Anderson,
Okay.
and she and Bjorn now live in Sweden with their 3 daughters,
Gosh.
ages 7.5 to 2. And my son went to Carnegie Mellon and got a bachelor's degree there and a master's in electrical engineering, discrete math, computer science, and went to work for Google in California
Wow.
in 1985, and he's still with Google, living in San Francisco. And so the 2 children, my wife, after Carol, after the kids got to a certain age, went back to Vanderbilt and got a PhD in history, and has had a full-time teaching job at Volunteer State Community College since then. She is also the sort of official historian of Metro
Right.
Nashville, and appointed by the mayor and confirmed by the council, and she does an enormous amount of unpaid work,
Right.
and lecturing on various topics related to history, and
Yeah.
and is active in other organizations like the Tennessee Historical Society. She writes and publishes on topics of American and Tennessee history.
And I know that her tours of the cemetery are must-see events.
That's right. That's right.
So what changes evolved have you noticed in the practice of law during all these many years, for better or for worse?
Well, obviously, the size of the bar has grown dramatically. I think the first meeting of the Nashville Bar, the December annual meeting and banquet that I attended, which was probably the fall of 1973 or maybe 1974, they announced that I think the membership had gotten up to 1,000.
Okay.
So you can see how, the bar has grown. Obviously, the bankruptcy bar grew tremendously after
Right.
after the passage of the Reform Act, and there were these people in Congress who a few years later were saying like, well, my goodness, it was like all of these bankruptcy cases being filed, and but it's kind of like, you go out and you say one day, we've got this road out here and it's in bad shape and it's only 2 lanes and it's got potholes and the bridge is deteriorating, and so to improve transportation from point A to B, we're going to build this new 4-lane highway, and it's, with all of these, wonderful conveniences, and you do that, and then people want to drive on it. And then everybody's saying, well, there's all this traffic congestion on the superhighway now.
Yeah.
And that was kind of the experience with the new Bankruptcy Act. It was kind of like, it had been sold on the idea that the old act was not very usable and was not very functional and needed to be improved. So they did all of these things to improve it, and the bar said, great, we'll use it.
All right.
And then all of a sudden you've got people in Congress saying, oh Lordy,
Yeah,
all these bankruptcy cases being filed.
right.
And so the bankruptcy bar has grown. Obviously, technology has changed a lot. When I started out, there to dictate. I had a dictating machine that you put in a little red plastic disc that kind of looked like a 45 RPM record.
Right,
And as you dictated, you actually cut a record.
exactly.
And of course, you couldn't go back. And
Right, no.
You couldn't reverse and dictate over. I remember the first fax machine we got, which was 1985, and I remember it because I was handling a Chapter 11 case in bankruptcy court in Knoxville for a company that had become, they were specializing in all of this computerized monitoring devices for nuclear power plants, and they had like 300 employees and were doing great guns. And then 3 Mile Island happened. And all of a sudden, there was all of this contraction in the nuclear power industry, and they had to go into Chapter 11. But they had a very talented CFO there who was into computers, and I mean, he had generate all of these wonderful spreadsheets on his Apple Mac computer.
Yeah.
And one day he said to me, I need to be able to fax papers to you.
Yeah.
Because you're in Nashville and I'm in Knoxville, and we got this Chapter 11 case going.
Right.
And so I came back to the office that day, and after driving back from Knoxville, and said, I don't know anything about it, but we're getting a fax machine.
Yeah, right.
That's 1985.
Yeah.
So, the technology has just sort of moved on from there. And it's wonderful, and it does a lot of things for you. It's also can be a hair-pulling exercise at times.
And I imagine with you being in a litigation firm, you did a lot of times walking and delivering and filing things in the clerk's office, and all of that's changed, hasn't it?
Absolutely. When I first started practicing law, lawyers, when they finished preparing a pleading, they would personally walk it over to the courthouse and file it with the clerk.
Before it closed at 4:30.
That's right. And it was, there were some nice things about that. You usually met a lot of people and had some interesting conversations on your way to and from the courthouse. Right. And the fact that the lawyers were in the clerk's office and talking to the personnel there and, getting to know them was a plus. Nowadays, everything is filed electronically, and when that was coming up, I was very fearful about it. I just couldn't imagine how this was going to work, and thought it was going to be potentially a big problem. But today, I can't imagine doing without it.
Right.
Particularly when you're handling a case that's pending in another jurisdiction.
Right.
And, you can go online and, you can file a notice of appearance and get immediate electronic notice of everything that's filed in the case. In the old days, if you wanted to check the docket, you went over to the clerk's office and, paid them 25 cents a page, and they would print and they would copy the docket for you. And the entries on the docket were, kind of handwritten by somebody in the clerk's office. So
or check out the file and then just sit in there to look at it.
Right. So a lot of things have changed in that regard.
Right.
Some for the better, and most of these things have an upside and a downside. I think that people thought that when all of the computerized activity came into the law offices, that it would cut down on the use of paper. I think it's done just the opposite. I mean, the paper usage has gone up, and I remember because of the difficulty of copying things, it's so much easier in litigation now to have 12 plaintiffs and 45 defendants in a lawsuit, and
Right.
The complaint is a page, an inch and a half thick, and before you know it, the file is taking up many linear feet in your office. I remember when I was working in the Chancery Court that from time to time I would be sent up to retrieve an old file from the early 1900s
Right.
from the archives, and those were mostly kept on the 7th floor of the Davidson County Courthouse, which had once been the jail. There were still cells up there on the 7th floor
Wow.
with iron bars, and that's where they kept a lot of these records. And what was remarkable when you would go in there was how small the file on a particular case was. And there were a lot of handwritten pleadings. And when a case would be appealed to the Court of Appeals, someone in the clerk's office, a scrivener,
Right.
would write out in hand the appellate record. It would go up in that way.
Okay.
So, that meant that those constraints meant that litigation had to be very economical.
Right.
Now, with all of the technology at our disposal, those limitations don't apply, and consequently litigation expands
Well, and you mentioned going to the courthouse and seeing a lot of people. We kind of have that in the bankruptcy on motion docket,
yes,
which unfortunately this last year, a lot of that's gone away, hasn't it?
right. And that was one thing I remember from the early days in the Chancery Court. They had motion docket every Friday. And,
Right.
half of the Nashville bar would be over there in one courtroom or another, and it was an opportunity to rub elbows with the lawyers and have a lot of
Yeah.
hallway conversations, some of which were just enjoyable and some of which were actually productive.
Productive. Yeah, you get a lot of things done in the halls.
That's
And on
right.
Tuesdays is when we did it in bankruptcy court.
That's right. And so those things have their place.
That's right. What do you think about things this day and age with, of course, obviously it's been a very unusual year that we've experienced.
Right. And I know that, a lot of people have, and businesses, particularly in the hospitality industry, have been under a lot of financial stress as a result of the lockdowns and so forth. You would think that would be having an immediate effect and an upward tick in bankruptcy filings. I think that has been attenuated to some extent by all of the government aid programs that are out there and the immense amount of money that the federal government is putting into the economy right now. But so I'm not sure where this will all go.
Right.
And a lot will depend on whether some of these appropriations get made for all these infrastructure projects that are being talked about. That could be a boon for a lot of people.
Yeah. Well, and we've been talking about kind of progressed through the practice of law in the 90s and a little bit in the 2000s. What's been keeping you involved in recent years? When I say recent years, the last 2 decades or so.
Yeah. Well, just a variety of things. Just kind of all over the map. Some debtor Chapter 11 cases, like, for example, that New Life case that you were involved in representing the creditors committee. That was a big project for us. And a good many out-of-court workouts and some creditor work. I've got a case going on right now. It's in state court, and it involves the Tennessee statute on fraudulent conveyances, but defending an alleged fraudulent conveyance under Tennessee law, and it turns out to be a pretty interesting issue, which is being litigated in Williamson County right now.
Okay.
So just kind of a wide variety of things.
Yeah. And you got involved in management, didn't you, in your firm?
I did. I served as the managing partner for 5 years, starting in 1994 through 1998. So I did a 5-year stint as the managing partner.
Yeah.
And that was enjoyable, but it's always a conflict because you're trying to hold up your law practice at the same time. And so when you're working on administration, you feel like you're cheating the law practice, and when you're doing that, you feel like you're not doing your job on administration as well as you should. So that's a balancing act that I guess the managing partners in most firms kind of experience. But yes, I did that.
Looking at this point, any kind of either regrets or feelings of great accomplishments that you'd like to emphasize?
I don't know of anything in particular that I would cite. I do think, one thing that that you have to console yourself with, I think, is, helping lots of people over a long period of time get their problems resolved. They come to you, and for one reason or another, they're stuck, and they can't move forward because of this circumstance or that circumstance, and, getting them beyond their problems so that they can function again is very important to them, and I think that's what we're all about. You kind of if you're a private practitioner and you're looking to for a monument to yourself from your work, you're probably going to be frustrated because, you go out and do this wonderful work, you write this brief, you maybe win a great case and it produces an opinion from the Tennessee Supreme Court.
Right.
And you think, I've really made a contribution to Tennessee law, and the next year the legislature comes into session and writes a statute to undo all of that.
Right.
So, that's one impression I have looking back over all of the fine legal work that I've done over the years is how much of it has been effaced by changing times, changing laws, changing circumstances. So, as I say, if you're looking, if a monument to your work is important to you, you probably ought to be in another profession. I think even, for academics, the same thing is true. You write this wonderful definitive book or law review article on a particular subject, and in a few years it's obsolete.
Right.
In many cases. So, it's just the nature of the work we do. And
So you've been practicing a long time. How much longer do you plan on continue, or is there any other activities that will keep you busy?
You know, I don't have a definite stopping point. I do want to retire. I do want to fully retire at some point. I'm not one of those who wants to be taken out of the office with his boots on. I'm looking at that, and obviously that will be kind of coordinated a good deal with what my wife Carol wants to do in terms of her profession. But so we will coordinate on something and hopefully have some years of retirement when we still have our health and mental faculties and can enjoy our grandchildren and our children and so forth. But I don't have a definite date drawn in the sand yet.
Yeah. Well, you've had a remarkable career, one that you ought to be truly congratulated for.
Well, thank you, Bill.
Certainly in the bankruptcy and in every other aspect that you've been involved in. One area that we didn't probably fully cover or adequately cover was back in after the bankruptcy code was enacted. They ran into a little jurisdictional issue that kind of brought everything to a screeching halt. Why don't you talk about what occurred and how that changed things for a while?
Right. Well, you know, this problem had a very old source. You know, under the old act, there was all of this distinction between what was then called summary jurisdiction and plenary jurisdiction. And the district courts, which were Article III judges, exercised plenary jurisdiction, but the bankruptcy judges, or referees as they were called then, had only summary jurisdiction unless the parties consented otherwise. So this had been a problem under the old act, and there was an effort made when the Reform Act was being negotiated to solve it. One of the proposed solutions was to make the bankruptcy judges Article III judges. This had generated a lot of opposition, including from the Chief Justice of the Supreme Court, Justice Berger at the time, who went and personally lobbied Congress not to make the bankruptcy judges Article III judges. So when the new act came in, it was made clear that they were Article I judges. They were adjuncts, was the term that was used, of the district court. The basic bankruptcy jurisdiction was reposed in the district courts, which then referred matters to the bankruptcy judges as Article I judges, similar to the way district judges refer matters to magistrates. And as things developed, you know, this issue of jurisdiction, you know, came to a head in the Marathon Pipeline case, in which the question was raised as to the extent that the bankruptcy judges could exercise what would have been called in the old days plenary jurisdiction, basically the ability to try and enter dispositive findings and conclusions in a something other than just what was germane to the administration of the case.
Right.
And the Supreme Court, not surprisingly, said the bankruptcy judge can't do this and can't enter orders in these matters other than certain administrative things. So it kind of threw the whole bankruptcy system into chaos, and we had a situation there where we were going over and trying matters in front of the bankruptcy judge, and then proposed findings and a proposed order were being taken over to the district judge to sign. And it was a mess, and I guess created lots of tension. I remember one afternoon, Steve Miller, long deceased, but a member of the bankruptcy bar, and I had some kind of case, and Steve needed a hurry-up order entered in this case to do something. I can't remember now exactly what it was, but I was agreeable to it. I was on the other side. So we went, the bankruptcy judges had said, we can't hear this. And I will say parenthetically, while we're at this point, that, I and most of the bankruptcy bar, I think, would agree that we all were blessed for many, many years, 30 years, to have Judge Payne and Judge London on the bench. And of course, they've been succeeded by another generation of very fine judges. But, the two of them really made practice a pleasure during those years, and I think really caused the bankruptcy practice in Nashville to advance light years beyond what it had been when I first started practicing. But anyway, Steve and I went over to the courthouse to find a district judge, and the only judge in the courthouse that afternoon was Judge Nixon. And we told him what we needed, and he said, well, go down there and see the magistrate, Joe Brown, and let him hear it. So Steve and I went down there, and Joe was a very good sport about it. I mean, he convened court, and we had a hearing for an hour or two. I don't think it got resolved that afternoon, but we did have a 2-hour hearing in front of Magistrate Brown, and within the next day or two, we had to, follow up and get an order entered, and so now we were going to Chief Judge Morton, who we called him up on the phone, and he proceeded to just go up one side and down the other. I've never heard of anything so ridiculous in my life, taking a bankruptcy issue to a magistrate. What were you thinking? That's the most absurd thing I have ever heard. And said, well, Your Honor, we came over here, and the only district judge in the courthouse was Judge Nixon. He told us to go down and present it to the magistrate, so that's what we did. Well, I've never heard of anything so ridiculous in all my life. And went on in this vein for a couple of minutes, and then finally he stopped and took a breath and said, all right, I've vented my spleen. What do you boys want?
Let's get down to really getting to the details.
So that's my anecdote on the marathon.
Well, and of course, the Article 3, the big significance is there's lifetime tenure there.
Yes.
And Article 1 is based on legislation, and you don't have that a lifetime. So there's a limited scope as to what the bankruptcy judges could rule on.
Right. And, Congress came back and tried to fix the marathon problem, and they passed a statute to do that. It really didn't fix it.
Right.
Because I don't know that it can be satisfactorily fixed short of making the bankruptcy judges Article 3 judges. But my impression is that the bankruptcy bar generally across the whole United States has just sort of tacitly said, we're just not going to raise this issue.
Yep.
And get our business done as best we can without, raising this old conflict. But the fundamental issue is still there. It's never been really satisfactorily resolved.
Right. Well, you're exactly right about us being fortunate to have judges that were both leaders nationwide as well as very good in the courtroom. Are there any particular stories that you recall of that are appearing before either of these judges?
Well, one of them I recall involving Judge Payne that came out of the H&S transportation case, which was the barge case, and I got called by some lawyer in Illinois who was handling a case involving two barges that had collided on the upper Illinois River, and there was a lawsuit pending up there and involved $10,000 or $15,000 of damages that one barge had done to the other. And he wanted to file a motion for the bankruptcy judge to abstain under the statutory provision to do that. And I was not really encouraging him, but he really wanted to try that. And so I prepared a motion, and the case was being heard by Judge Payne for abstention. And went over one day on the motion docket to hear it, and I think this was a motion docket that was devoted pretty much to this case, and the courtroom was full. There must have been 100 lawyers in the courtroom that day. And this was before Judge London went on the bench. He was representing in some capacity some of the debtors. And so my case got called, and I got up to address it, and Judge Payne said from the bench, Mr. Bucy, he said, are you aware that I have already heard 5 different motions for abstention in this case, and I resolved every one of them against your position? And I said, no, Your Honor, I did not know that, which was the truth. And therefore, I'm approaching this with an open mind. And Judge Payne, without missing a beat, said, well, that makes one of us. And but he heard me out.
Yeah.
And after hearing me out, he granted my motion and let the lawyers in Illinois go forward with their case.
Yeah.
One other remarkable incident I'll talk about that involved Judge London, and this was in the Vanderbilt Plaza case, and we had a hotly contested issue argument one afternoon in front of Judge London on this issue of the separate classification of the secured creditors under secured claim.
Right.
Brad McLean was on the other side arguing it for the secured creditor. And we had an extended argument, and at the end of it, Judge London, as was often the case, delivered very involved and detailed findings and conclusions from the bench adverse to our position, and said that we could not separately classify.
Mm-hmm.
And so that was the end of that, which looked like it was the end of our plan, because if we could not, cram down the secured creditor, there was no chance to reorganize that. So we all came back to the office, and we were obviously disappointed. And next day, we all got a call from Judge London's office, and he said, I want everybody to come back to court this afternoon at 1 o'clock. And we thought, well, this is kind of interesting. And so we all went back to court that afternoon, and he came in on the bench, and he said, after thinking about this overnight, I think I was wrong. And I think at this stage of the case, I'm not prejudging whether I'm going to confirm the plan or not, but I've got to let the debtor at least stage a confirmation hearing with the separate classification in there. I may deny confirmation on that basis or some other, but if I rule on this classification at this preliminary stage, the debtor never really gets a hearing on the plan. And so, forget everything I said yesterday. We're going to schedule a confirmation hearing. And in all of my career, I don't think I've ever seen a trial judge do that.
Right.
I thought it was really remarkable. And I thought it was not just because I came out on the right side of that case, but I thought it bespoke an amazing confidence on the part of Judge London in his ability to ferret through these cutting edge issues to do that. And he earned a great deal of respect and admiration from me that day.
Yeah, interesting.
So I don't know if there's anything else you want to talk about.
Yeah.
I guess I would just say in conclusion that I feel like I've had a very good career. It's been very satisfying to me most of the time, and I think that the practice that I've had has made the best use of such talents as I have. I can't imagine what other line of work I could have gone into that would have enabled me to use my talents as I have like this. A lot of things I can't do. A lot of things I wish I could do that I can't do.
Right.
But this practice has been a good match for me. Somebody said, that's talking about the world, that the world is perfect. It's a mess. And we are a match for it,
Right.
and it's a match for us.
Yeah.
And that's kind of how I feel about the law practice. It's been a very good match for me, and so I have no regrets. I can't imagine what else I could have done that would have been more productive or satisfying.
Well, you've always had such an even disposition and very intellectually and approaching of the solutions and trying to reach solutions, and that's been a great hallmark of being a good bankruptcy lawyer. So,
Well, thank you.
I would say it's been a very good fit for you.
Yep, I agree. Thank you very
Yeah.
much.
Well, thank you, and appreciate this opportunity to have your history and thoughts being put on record. I think it's been a very good program.
Yeah, well, I appreciate you doing it.
Yeah. Thank you.